Justice Shah was elevated to the bench at the Lahore High Court in 2009, and after serving as the Chief Justice of the Lahore High Court for almost 2 years, he was elevated to the Supreme Court of Pakistan in early 2010. Your Lordship, if you might join us on stage.
I was telling Sarah that this photograph is a misrepresentation. I don't have any hair left anymore at the Supreme Court. And this is an old High Court photo, by the way. So I think that needs to be updated a little. Assalamu alaikum, everybody. Let me just settle down a little. So let me just share my favorite quote on the subject and then get on with things. No visible symptoms, no running nose, just a head full of darkness. No fever, no rash, no fractures, no sprains. Just a longing for something unable to explain. And that touches me very much, actually, and I thought I'll share that with you. So, Your Excellency, Mr. Hutchinson, the High Commissioner of Australia, Justice Khalilur Rahman, it's a privilege that he's here amongst us today. He's one of the judges that I learned company law from. And I had just started practice, and he was heading the company bench at the High Court. And he made us be on our toes all the time, and we learned the company law through you, sir. Thank you so much for all those taunts and all that, sir. It's a pleasure that, thank you to the Justice Project. Thank you to Sarah Bilal for having me over for this wonderful afternoon. I think it's a great practice and a great tradition that she's setting, that we're commemorating judgments of the Supreme Court which are making a difference. And I think that encourages us, because nobody ever calls us anywhere and says anything about our judgments. They mostly criticize. But thank you for doing this, and it's such a privilege being here. And thank you for being in such an august company of lawyers and activists and practitioners and such able people. I also wish to, before I move on, once again pay tribute to the giants that we had mentioned earlier, Dr. Mubashir and Justice Shakilur Rahman, who's been a friend, a wonderful person. So I thought I'll mention them. That's important, because I think they really moved the whole agenda forward. And we just, actually actualized it later on in the court, but a lot of effort went in there. I'll be sharing I don't know if you've read the judgment. It's a long judgment, and I don't know if you read judgments of our Supreme Court that often. But now that I've been asked to talk about the judgment, I'll just touch upon some of the salient features and also point out what we've really held and how we've gone forward, you see, where we've traversed area and, new boundaries, cross new boundaries, and that's something that I want to share. But let me just, on a procedural note, tell you that it's a 5-member bench judgment. We could have 7 members also. We can have the whole full court also. We can have 3 members also. But this was a 5-member bench judgment, which signifies a certain importance of the issue and the gravity of the issue. I also wish to mention the author judge, who is Justice Mansoor Ahmed Malik. He did a wonderful job. I mean, the credit actually goes to him, because he's the one who wrote it, even though we all sort of worked on it, but he wrote it. And author always takes the credit. So my salutes to him for a wonderful judgment that he's given us. The other judges I also need to mention who were on the bench: Justice Sadar Tariq Masood, Justice Ijazul Ehsan, Justice Mazhar Alam Mia Khail, and I, being the youngest member on the bench, even though I don't look young, but it was the youngest member on the bench was myself. Thank you. The amicus who helped us in this is very important, because we would have not understood. This was a new territory for us. I ended up reading so much about psychiatry and psychology and mental illness that I'd never read before. And thanks to Brigadier retired Professor Muwaddat Hussain Rana, who's sitting right here, he was amazing in the court. He was just brilliant, absolutely brilliant, and made us understand what all this is about. He actually brought the science to the courtroom, and thank you for that. I also want to thank Barrister Haider Rasool Mirza. I don't know if he's here, but he did a wonderful job on the legal framework of the laws that were there. There are other unsung heroes too. I mean, Sara Bilal sits here and her team who did wonderful work, and she helped me with a lot of material, and she gave me time, and we talked about the issue. So it was, we also evolved as we went about writing this judgment or thinking about it. So it was very educational for all of us. So it's a story of 3 convicts, actually, which starts off with all convicted for murder. All were convicted for murder. 2 in their early 20s and 1 in the late 40s. Several decades they spent behind bars, you see, before the matter really came up. The whole case is post-conviction. They were behind bars and the matter came up, and you'll be surprised, and I'll give you a little more facts, that they had lost throughout in the legal system of Pakistan, and yet the matter came up again and they were granted this relief, which is itself pretty amazing, actually. So 2 of these convicts never took this plea throughout the litigation that they did up to the Supreme Court regarding mental illness, and it was just brought up at the very fag end when the black warrants were issued and they were about to be executed, and they just raised this question, or the family raises the question, and how things turned for them, which itself is I think, quite interesting. So the profile of the 3 gentlemen of convicts, one being a lady, are as follows. Imdad Ali, who probably, there was a photograph or there was a sketch here, is 45, indicted for murder. He moves an application. He's the only one who moves an application earlier to determine his competence at the trial level. But that was dismissed. And that's what I want to highlight. There was no sensitivity at all, you see, till this case came up. And I think that's what makes it a landmark case. The sensitivity itself. We were totally unresponsive. We did not understand what we're talking about. So this application, when this comes up before the trial court, the judge looks at it. The magistrate or the additional session judge will probably look at him. How could you look at a person with mental illness and decide whether he has mental illness or not? And he just dismisses the application, even though the wife appears in the court, and that's Safia Bano, by the way, the more famous lady now. She was the wife of Imdad Ali, and she appears in court, and she makes this deposition that my husband has had supernatural beings, he's talking about supernatural beings, he has symptoms of abnormality, but this didn't really weigh much on the mind of the judge, because the law at that time earlier, you had Lunacy Act in 1912, and you talked about idiots and lunatics, and that's where it stands. And it never really grew, and people never really understood. So he was finally convicted in spite of this statement having been made by the wife. One would have imagined the court would have, inquired into it a little further. The wife is saying that for the last 4 years, this has been happening to this gentleman, but the court dismissed it. And there was this death sentence that was granted to him. He files appeals before the Supreme Court, loses. He did not file a review, but he went to the president for the mercy petition. Black warrants were issued. And all these years he's incarcerated, by the way, going through whatever mental trauma that he's going through. And once again, I must give credit to Safia Bano, and I wish if she's there and you would have invited her today, because she really moved the whole thing. So Safia Bano, once again, when the black warrants are issued, moves an application before the High Court and says, my husband suffers from mental illness and something has to be done about it. And that's when that application is dismissed. That comes up before the High Court. High Court dismisses that application once again. Not realizing the sensitivity, the person was on a black warrant and would be executed soon. I mean, it's just commonsensical. One would have probably interfered and inquired into it a little, but no. The application was dismissed. Finally, the High Court dismissed it. We dismissed it too. I wasn't at the Supreme Court then. We dismissed it too. She filed a review. And so did the state and the IG prisons also. And it was the review that was before us that we dealt with, and I'll talk about that later. When we talk about the second convict, which is Kaniza Bibi, 24 years of age, she was convicted for murder on death for 6 counts. So she murdered 6 people according to the record. Her appeal again, all the way up to the Supreme Court, was dismissed. And she was convicted. She does not file a review. She goes for a mercy petition before the president, which was dismissed. approached the court for conversion of her sentence to life on the ground of mental illness for the first time in 2010. She's probably convicted a decade earlier or so, and she files an application then. And then that is dismissed again. That comes up before the Supreme Court, and that is dismissed again. But for some reason, the mercy petition once again before the president stays the execution for 3 weeks and sends the matter to the Punjab Institute of Mental Health. And they come up with a report, and the report says that she's suffering from schizophrenia. So mental illness was not a ground in her trial throughout, by the way. I mean, this is at the fag end. When she's about to be taken to the gallows, there's an application moved. So on a report of this, the superintendent jail, the CJP at that time exercising his suo motu powers. And I think that's the best ever suo motu exercise to my mind. And that is, to my mind, what suo motu is for, frankly. That's quite a different subject, but that is what suo motu is for. And hence the case came up before us. We look at Ghulam Abbas, 23 years of age, convicted for murder and sentenced to death in 2006. His appeal all the way to Supreme Court dismissed. I mean, you've never heard of a case where everything till the Supreme Court is dismissed and yet the relief is granted, which is, itself very novel. Review was dismissed. Mercy petition to the president dismissed in 2019. I mean, this is not really happening in a fast-track basis. I mean, the person is behind bars. Just imagine that. Decades spent behind bars while these petitions are coming up. Black warrants were issued. Execution fixed for 18th of June 2019. Petition by the mother under 184.3, which is a provision that you can come to the Supreme Court directly. The mother comes up and moves an application that my child is not well. And he always had severe learning disabilities from childhood. There's a documented history of mental illness in jail, and he's been prescribed medicine also. So petition was entertained, and execution was stayed in 2019, and the matter came up before us. So the uniqueness of the case is that all the three had lost at the highest court of the land, and yet their application with some sort of understanding was taken up. But I tell you, whoever entertained the applications and fixed them were not really fully aware of what mental illness is, which we learned much later. But somehow the matter was taken up in that sense. So let me also, at this time when we started looking at the case, we were hearing arguments and all, and we realized that look at the statutory landscape. What are the laws on the subject? The law on the subject was the Lunacy Act 1912, and there's a gap of 89 years. We live with Lunacy Act for 89 years, which just talks about an idiot and a lunatic, and that's about it. And then, after 89 years, in 2001, you have the Mental Health Ordinance. For the first time, it defines what mental illness is and other shades and nuances that are attached to it. But that also remains on the statute book for a while, because 2001, and now this case comes up much later. So the statutory landscape wasn't very encouraging, wasn't really there. And I think that's important to understand, that people never understood because there was no definition. There was no law talking about it. We had just left it in the corner like Lunacy Act 1912, okay, forget it, untouched law. And I think that's the awareness issue. That's why the sensitivity wasn't there. That's why there was no responsiveness on the part of judiciary or others, you see, because there was no law looking at this area. So total lack of sensitization. If you look at the case law, that's also very depressing. I mean, while the time we are sitting and looking at this case, we look at our jurisprudence, we always do, we look at our past cases, and wasn't encouraging at all. Once again, we thought that there was no sensitization. Judgment said that, the assumption is that everybody is sane. We're all normal, says the assumption, unless something else is proven. Now, how would a villager come forward and prove such a technical thing that there is mental illness, and then how would she prove it? I don't know. So it was, many cases were dismissed on this ground that, oh, sorry, the accused failed to prove that there was mental illness. And today I understand how technical it is and how sophisticated and complicated it is, and you're expecting somebody from a remote district to come forward and prove it, that I have, or my son or my brother or my husband has mental illness. So it was just left to the accused to prove, and otherwise they were convicted and they were ignored. So if you get a feel of the jurisprudence over the years, when we sat on this judgment, we thought nobody really cared. There was no awareness, total insensitivity, and totally unresponsive towards the issue of mental illness. In fact, the terminology mental illness wasn't really there in that sense. So we got started on this work with the help of Dr. Saab sitting here, Professor Saab sitting here, Brigadier Saab and Professor Saab sitting here, who started teaching us about all this. And we started learning, and so we thought, let's look at, so the judgment is structured on all the stages of the trial. What happens if at the time of the commission of the offense, the person is suffering from mental illness? What when during trial, he's to take up a defense and he suffers from mental illness? What at the time of execution, when he's about to be taken to the gallows, he suffers from mental illness? So these three stages were examined by the court, even though the court only had post-conviction matters, but they opened it up. So that's something also that I want to talk about. The judgment goes beyond the the scope of the case that was brought before the court. So the three stages were discussed in detail. What helped us tremendously was, of course, the mental health ordinance itself, which we started off reading for the first time in 2000. It's a 2001 law. And it talks about mental disorder, mental impairment. These terms were new to us. That's why I want to sort of read this, and I want everybody to understand that these are the terms that exist. So mental disorder, mental impairment, severe personality disorder, severe mental impairment, mentally disordered prisoner. And these terms weren't in our literature. How would we decide a case? So this is very important that the legislation helped us get started. And then, of course, there were decisions from foreign jurisdictions that came forward. We went through that, and we went through a number of other material that was provided. International conventions were provided, and we started understanding that how far, we were from where the world is. We were really far behind. So the first thing that really comes out of the judgment, and I just want to highlight what we've really held, you see, what the judgment talks about, is the definitional framework. We've actually now made it quite clear. And this is no end, you see. We will be developing, and I'll be talking about revisiting Safiya Bano if chance is given to us at some stage, and I'll talk about some of the ideas for the future. But what this judgment comes out with is the definitional framework. Recognition and understanding of medical science, which is constantly evolving. So this is a material judgment which says, please open your doors, courtroom doors, and bring science in. You can't decide matters without science. And not only in mental illness, you talk about environment, you talk about climate change, you talk about gender, you talk about rape, you talk about science. Science is such an important part of jurisprudence, and for us to understand, judges who do not understand science, who are not in touch with science, will not be able to produce jurisprudence. So I think this judgment opens the door. So some of the things that you might not, by reading it, appreciate or feel, I just want to highlight as a judge, I feel it's a great judgment which opens doors for science to walk into our courtrooms, and I think we should do that. So let me quote some of the passages from the judgment, because Justice Mansoor is not here, so credit goes to him, but let me read it. On the definitional framework, therefore we are of the view that a limited definition of the term mental disorder or mental illness should be avoided, and the provincial legislature may, in order to better appreciate the evolving nature of medical science, consider to appropriately amend the relevant provision of mental health laws to cater for medically recognized mental and behavioral disorders as notified by WHO through latest edition of ICD. Basically, the judgment opens the door of be current. You see, keep on bringing the new changes and evolving in the area of medical science or in the area of mental illness. It goes further and says, we consider it appropriate to direct that the terms unsoundness of mind and unsound mind occurring in PPC and CRPC and the prison rules be substituted with terms like mental disorder, mental illness. The term lunatic, which occurs, shall also be substituted appropriately. So we discarded the words. So that was really, putting the past behind and moving forward. So getting rid of the words, the literature that was in existence at that time. So that's one area that we did, and I'm very proud of that. Then we talked about different stages, which I mentioned earlier. We talked about different stages of the criminal trial. and how mental illness has an effect. We talked about the stage where the commission of the offense, at the time of the commission of the offense, the person suffers from mental illness, or during the trial, or at the execution level. And we talked about a lot of law, which is already mentioned in our criminal procedure court in PPC. And we finally hold that, and I want to read it like this, because I think a lot of young lawyers could take what I'm trying to say and develop it further, you see. Even though the judgment says that the accused has to prove at the initial stage, in the first instance where he says that at the time of the commission of the offense, he was suffering from mental illness, the onus under the evidence law is also on the accused. But then it opens the window a little, and it says if there's any other material on the record, even brought in by the prosecution, could be relied upon by the accused. And also, I would read it this way, that I think prosecution ought to also satisfy the court that no, he's not mentally ill. And I think we need to push it in that direction. When I read from that portion, it is the basic, and I use these words, and I think there's a lot of bandwidth there. It is the basic duty of the prosecution to prove its case against the accused beyond reasonable doubt. And within its fold, you could say that there was an issue regarding his mental illness. So please establish that also. And the prosecution will not be absolved of this duty, if the accused is unsuccessful in proving the plea. So if he might be unsuccessful, the prosecution has to establish that he's not mentally ill. And I think that is the direction. So basically, we're putting the prosecution on the mat also. Then we go ahead, and during the trial, the law says that the trial will stop because it will be kept pending if it's discovered. But what's important is that the law simply said that the magistrate or the court will look at the person, maybe, seek some opinion here or there, and it was very casually being done, you see. I fail to understand as a judge that how would I ever, sitting at the Supreme Court with all this judicial experience, tell that a person suffers from mental illness. I mean, something could be very obvious, but you can't really, you see. So I don't think it's within my domain to even get into that area. And the minute anything is on the record which even slightly points towards that, I think one should go ahead and hold a very serious inquiry. And that's what the court, and that's where the departure takes place, and I think it becomes a landmark judgment. It says, hold an objective inquiry. I'm nobody. I don't know who this person is, but you sense that there is something, or even if you don't sense, there's something on the record which says that he's suffers from mental illness. An inquiry ought to take place. And I quote, once the court has formed a prima facie tentative opinion that the accused may be incapable of understanding the proceedings of trial or make defense, it becomes obligatory upon the court to embark upon conducting an inquiry to decide the issue of incapacity of the accused to face trial due to mental illness. Medical opinion is a sine qua non in such an inquiry. Now, this is where we bring science in again. We're not going to decide. Let the experts do the job. And experts sitting there, I mean, they did a wonderful job anyway. For this purpose, the court must get the accused examined by a medical board. Now, medical board comes into the literature for the first time due to this judgment. To be notified by the relevant government, consisting of qualified medical experts in the field of mental health, to examine the accused person and opine whether accused is capable or otherwise to understand the proceedings of trial and make his or her defense. The report, opinion of the medical board must not be a mere diagnosis of mental illness or absence thereof. It must be a detailed and structured report. Now, this is very important. Structured report with specific references to psychopathology, if any, in the mental functions of consciousness, intellect, thinking, mood, emotions, perceptions, cognition, judgment, and insight. You see, there might be words coming from Professor Rana, but we've adopted them now. They're law of the land. The head of the medical board shall then be examined as a court witness, and such examination shall be reduced in writing. Both the prosecution and defense should be given an opportunity to cross-examine him in support of their respective stance. Thereafter, if the accused wishes to adduce any evidence in support of his or her claim, she should be allowed to produce such evidence, including expert opinion, with the prosecution given an opportunity to cross-examine. So, this is taking things further, because the law did not talk about. The law said, well, we'll just make a tentative understanding. And we've been rejecting that over the years. For the last 80 years or so, since the Lunacy Act, we've been dismissing cases because we think, no, he's not a lunatic, maybe. So similarly, at the execution stage also, this is where the retributive justice concept comes in, whether at all, how would you serve a retributive justice or bring somebody subject to retributive justice who does not understand what he's being, punished for? So when it comes to execution, and suppose the person develops a mental illness, the court said that killing someone who has no capacity to understand his crime or punishment offends humanity. Lack of retributive value in executing a person who has no comprehension or awareness of penalties, existence, and purpose. You see, so it's very important that this execution cannot take place for a person who suffers from mental illness. And I'll be sort of submitting some of the other things also. We also relied on number of international documents and treaties, conventions, Nelson Mandela rules, and there's a number of things. It's a wonderful read. Have a look. You'll find a number of things there. And I once again like to quote another important paragraph which sort of sums this up in the end, which talks about the execution in particular, because it talks about, as I said, about inquiry, which is a very important thing, an objective inquiry, and then now about the execution, that somebody suffering from mental illness will not be executed. You see, he will not be put to that, that punishment. And I quote, after considering the material discussed herein above, we hold that if a condemned prisoner due to mental illness is found to be unable to comprehend the rationale and reason behind her punishment, then carrying out the death sentence will not meet the ends of justice. However, it is clarified that not every mental illness shall automatically qualify for an exemption from carrying out the death sentence. This exemption will be applicable only in that case where a medical board consisting of mental health professionals certifies after a thorough examination and evaluation that the condemned prisoner no longer has the higher mental functions to appreciate the rationale and reasons behind the sentence of death awarded to him. To determine whether a condemned prisoner suffers from such a mental illness, the federal government and the provincial government shall constitute and notify medical boards comprising qualified psychiatrists and psychologists for public sector hospitals. This is a direction, and building new institutions for this. Then the other important thing, as I mentioned earlier also, but they also dispensed with the word civil surgeon and medical officer to be replaced by medical board. It becomes more institutional in its character to deal with these issues, which comprises of experienced psychologists and psychiatrists. That's the direction given to the government. So we know that the decision finally that came out was that the death penalty was converted into life imprisonment for all. And for one, the mercy petition is pending. I don't know what's the status. Maybe Sarah Bilal could tell us later. But the mercy petition was pending before the president, and a direction kind of was given that the president would look at the mercy petition in the light of this judgment. So the judgment also goes beyond the trial and goes into the clemency process, which is before the president. So I think it goes into that area also, which is outside our legal thing. Number of other directions were given which are very useful, and I'll just move on to the future, is that the federal government, all provincial governments shall immediately make necessary amendments in the relevant law. So we are waiting for those amendments to come, and I think the activists and the people who are looking into this area will ensure that these amendments do take place. Similarly, amendments in the prison rules. They also talked about setting up new security, high security forensic mental health facilities which need to be established. Medical boards need to be established. A lot more awareness has to be done, and so the judicial academies have been asked to start training programs. Our judges need to understand. Our lawyers need to understand. We don't have a law program in any law college that probably deals with mental health. I mean, I've been teaching for a number of years, haven't really come across mental illness or mental health issues or mental health law for that matter. So I think it might be high time for Justice Project to maybe initiate a course at law colleges, or for the members of the bar to look at the mental health issues. This is an important area. What could be more dearer to human rights than mental illness and mental health? And I think for young lawyers sitting here who want to practice further, we need to look into this area and could become experts in future in this area. Thank you for giving me that little break. Okay, so let me just, having said all that, let me just, one paragraph summing up the whole thing, and then I move on to the, what my ideas are for the future. So this judgment that reinforces the rights of mentally ill defendants in the criminal justice system, not only has the court established key safeguards for mentally ill defendants on death row, it has reiterated and upheld protections that must be afforded to persons with psychosocial disabilities at every stage in the criminal justice system, at the time of arrest, during investigation, trial, sentencing, in order to ensure that they are to guarantee due process. Also look at the clemency process which is under the president. It has also barred the execution of individuals who are severely mentally ill. So this is summarizing the judgment. So now let's revisit it, and if I were to sit on it again, and the case comes up again after this period that is 1 year that has passed by, and I would add a few things to it, and these are some of my humble sort of suggestions. These are purely mine, of course. I would look at it on a fundamental rights framework. I think the fundamental rights were not really talked about. Maybe we all missed that out, but I think that needs to come in. I would look at right to life, and I would look at right to dignity more than anything else. I would anchor the whole judgment on the right to dignity, which is so dear to me as a concept, and I think that's the only one of the strongest fundamental rights which is not subject to law, by the way. It's not subject to any law. You can never take away dignity from anybody. You could take away life, subject to law, but never dignity. Article 14, if you reread it again, you'll see that. So I would reconsider such a judgment in the light of the framework of the fundamental rights. I would not be too pushed if the prison rules are missing. I would not be pushed if CRPC isn't really talking about it. I have right to dignity, which I could turn the whole thing around on right to dignity, right to life, and right to fair trial. I think that is absolutely. There's so much power in these articles that all the laws flows from the Constitution anyway. So I would base it on this. So, and I want to talk about dignity a little, because that's very close to my heart also, and I think it's a very important area. So human dignity encapsulates the notion. We're coming up with a lot of jurisprudence on dignity, so stay tuned, as they say. Human dignity encapsulates the notion that every person has inherent equal worth. This simple but profound concept has three elements. First, every member of the human family has value. This is important. No one can be dismissed, ignored, mistreated, or abused as if their humanity means nothing. Second, each person's worth is equal to every other person. No one's life is more important than any other person's. Third, human dignity inheres in the human person and cannot be taken away. So if you have to clap, this is the time. And so I've already mentioned that you talk about the right to life, which is also very dear, and fair trial, talking about this process. I would also put a lot more burden on the prosecution. I would say that they have to establish the case, and if on the record it has come that the person suffers from mental illness, prosecution better clear that point, you see. So I might fail as an accused, but prosecution must establish that, no, sir, there is no iota that this person is absolutely normal. There's nothing wrong with him. I think prosecution needs to do that. And I think the courts now need to move after reading this, and I'm sure the courts will. I don't know if there's a term, but more pro-mental illness kind of inclination or propensity, have a more proactive approach towards mental illness. That's important. We should be now more talking about science. We brought science into the two-finger test judgment that's come out. We're bringing science into DNA being the gold star standard or whatever. So we want to bring in more science, and I think the courts need to bring in more science. But another thing that we need to introduce in, Mr. High Commissioner, this is actually quite an Australian concept also, the therapeutic jurisprudence. We need to move on to therapeutic jurisprudence. Now, this is for the well-being of the offender. The court must be so sensitive by looking at the whole thing that I must have a therapeutic effect on this issue. You can't sort of bring it in a company law matter or a taxation matter, but do bring it on when they're talking about human rights. So I think we need to introduce therapeutic jurisprudence in Pakistan. And we need to think about the well-being of that human being who's before us, and let's not be lost in what the prosecution is saying or what the accused could prove, but we could take up an inquisitorial role in such matters. So it need not be adversarial, to my mind. We could consider a slightly more inquisitorial approach in looking at this aspect. And, you know, if it is established that Imdad or Kaniz or Ghulam Abbas were mentally ill at the time when the commission of the offense took place, I would rather acquit them, you see. There's no offense that they've committed. They ought to have been acquitted. Why life? I mean, by convicting them, you're still punishing them, are you not? So that really bothered me throughout the case, but you know, you have a 5-member bench, you have to go along at the end, and you wanted to come up with a judgment, but that did bother me. If we can establish that at the very beginning he was suffering from mental illness, then you can't give him any punishment, no conviction at all. So I would rather acquit the person if there was such a situation. So I think in a case that might come in future, we might consider this aspect that acquittal would be the solution, and they ought to be sent to a facility or whatever, but we need to look at it with a human face. Where do they go? You see, we just decide things, but where does the person go? He's a human being, or she's a human being. So rehab, facilities, we need to have that kind of aspect to the judgment also. We can't just say, turned into from death to life, and then what? Where does the person go? He's suffering from mental illness. Should he not be, or she be sent to a mental facility? Or what are the steps regarding rehab? The Supreme Court could say, okay, give us a monthly report on what you're doing with this person. That is therapeutic jurisprudence. And I think Safiya Bano sort of pushes us in that direction. We need to go in that direction. I finish with a quote. The strongest people are those who win battles we know nothing about. Thank you. Thank you very much.